Hello friends, now in this video we'll continue based on the classification of the contract. Different classification we have seen. First was based on the creation. Now the second one is based on the validity. Now whether that contract is valid or not, based on a validity there are different types. The first is valid contract. Now what is valid contract? If all the essential element of valid contract are there, offer, acceptance, free consent, capacity, if everything is there, it's a valid contract. So there is no much confusion in valid contract. But other is void contract. Now again we have to understand two things. One is a void contract and other is void agreement. We need to understand both of the things because both are different. One is void contract. Now when I use the word void contract, it itself is very confusing. Why confusing? Because at one side I am talking about void, which itself means not enforceable. On the other side I am joining the word with the contract, which says it means it is enforceable. So now there is a confusion. Confusion is whether it's enforceable or not. The law says that the contract which ceases to become enforceable becomes void when it ceases to become enforceable. Now what does that mean? It says that initially when you made the contract it was valid. Maybe for example you just have gone to the purchase house, or you just gone to the purchase some land in your village. So when you made the contract, the other party was ready to give that land. It was a valid contract, there was offer, there was acceptance, consideration, capacity, everything was there, valid contract. But what happened later on, that government wanted that land and government has made all those land as under the government rule. So now that person cannot sell that land to you. So what has happened? That now that contract has stopped to be enforceable. It means that you cannot enter into contract or you cannot continue that contract with that person. So initially when you made the contract, it was valid. Later on, due to some event, because of happening or non-happening of certain event, it has ceased, it has stopped to be enforceable. That becomes void contract. The third thing is void agreement. Now when I say the void agreement, agreement is the first step toward the contract. There are two steps, agreement and enforceability. Now they are telling you that at the first step itself, it is void. So it will not go to the second step at all. And if it is not going to the second step, there is no contract at all. Now understand the difference. In the first case, there is a contract, valid contract at the initial phase. But later on, due to some event, it has become void. While in the second case, it is at the first stage itself, it has become void. Suppose for example, we can take that an agreement with minor. Now the moment you are making an agreement with minor, itself is a void ab initio. At that moment of time only it becomes void. It cannot go further. At that point of time only it has become void. If it is valid at the initial phase, it is void later phase, it's contract, void contract. But it is valid, it is not valid. It is itself void at the initial, first, from the beginning. Then we can say it's a void agreement. The third element or the next element is voidable contract. Now again it's a new word and we are having a whole chapter on that, what is voidable. But voidable in a sense, they are saying, the definition says that a contract which can be enforced by one or more but not by the other or others is called voidable contract. So again, what do we mean by the voidable? Voidable means where there is some force. We have understood the free consent. Law says if I have made a contract with some force where you were not willing to make the contract, in that case the party under the force, or we can say agreed party, the party in a loss, will have a right either to continue or to cancel. It means both the party will not have a right to cancel it. Only one of the party who is agreed party will have a right to cancel. So where in a contract one party is forced, other party is agreed party, and if that agreed party is having right to cancel the contract, it is called voidable contract. Just for example, that I want to sell my house to you and you are not ready to purchase that house. So I am threatening you to kill you. In that case, you are purchasing the house. Now the option is available to you. You may go to the court, you apply to the court and you say to the court that I was not ready and I was not willing to make this contract, I was not willing to buy this house. So court will give you right either to continue or you can cancel the contract, you can take that money back. That is regarded as voidable contract. Next is unenforceable. Unenforceable is all the elements are there, but because of some technical formalities you are not able to take it to the court of law. Maybe some writing is not there or maybe some element which you can rectify, right? That is called unenforceable contract. And the last point is illegal contract. Illegal, which is law says which is not permitted, which is prohibited. And all the illegal agreements are ultimately will become void. So void contract we have seen, void agreement we have seen, at the same time there is illegal. It is not permitted by law. And if it is not permitted and still you make that contract, it will become illegal contract. So based on validity we have seen valid contract, we have seen void contract, we have seen void agreement, we have seen voidable, unenforceable and illegal contract. Thank you.